I will now call 124-965 Tracey Murray and the estate of Robert Murray versus Miracorp Inc. and others.
May it please the court, Stan Bachman for appellants Tracey Murray and the estate of Rob Murray. Your Honor, I would request 2 minutes of rebuttal time.
2 minutes is granted. Thank you.
Your Honor, Your Honors, we are asking for this case to be remanded back to the trial court for a jury trial, so that the finders of fact can determine whether or not injuries that were suffered by my clients were reasonably ascertainable as required by the 2-year statute of limitations. We don't believe they were reasonably ascertainable, and we believe that there's at least there's 3, as we've argued in our pleadings to you. We believe there are 3 issues of first impression before the court that play into the consideration. And so I'll just go right to those. We believe that one of the first things is there a duty to investigate unavailable sources when attempting to reasonably ascertain an actionable injury? The lower courts, including the majority of the appellate court, have relied very heavily upon the statute that allows a stockholder to request an order from the court to review and record and inspect the corporate records. And they've relied upon that as part of the process with regards to whether or not my client investigated, finding that had they in 2011, very important here, had they in 2011 asked for a records inspection order, that they would have discovered all these wrongful acts of Mr. Goebel, and who was the 95% owner and president, director. He ran the company of Miracorp Inc. The reason why 2011 is so important is because in 2011, back to this, we don't believe that having to file a lawsuit to stay within the statute of limitations is reasonable. We don't believe that it's an available. We don't believe it's an available source. We're talking about the discovery rule in particular, and Davidson versus Denning in particular says that we had a duty to reasonably investigate available sources. When there's a fiduciary relationship and a minority stockholder, this court has said in Wolf that the duty to investigate is lesser or it's reduced. So that's another issue we've asked this court to consider as a matter of first impression is, what did this court mean when it said when there's a fiduciary duty such as we have here?
Let me drill in a little bit. Try to find a baseline here. You filed your lawsuit in February of 2019, which means you can anybody files, then you can reach back to February of 2017, no problem. What you need, here's the question I've got. Don't you need to get your statute of limitations to reach back all the way to 2011 because that's when the corporation was looted?
There's a couple of ways to answer your question, Your Honor. One is the record is there's a lot of things in the record that show that Mr. Goebel was concealing and hiding a lot of things that happened in 2011. Mr. Goebel was.
I don't care about that. That's what you're going to catch him doing. The point is there anything after the looting of the company in 2011? And just let me use that pejorative, that constitutes a cause of action?
There's yes, Your Honor, every year that goes by, there's continuing, I'll use your words, continual looting.
Corporations, my understanding of the fact was the corporation's gone around 2011, 2012.
Yes, Mr.
The
Goebel,
assets have been moved over to NTTS. And there's no activity anymore because it got looted and all the customers and everything got moved over to this other company. And your client is not a shareholder of that company. So your shareholder is holding 5% of an empty bag as a result of the misconduct, you would allege, of the defendants. So there isn't anything else after 2011, 2012 that you can hang your hat on, is there?
well, Your Honor, it goes back to being able to determine when the injuries were reasonably ascertainable. Because
But all the injuries are in 2011 and 2012, is all I'm getting at here.
that's correct. They weren't discovered by my client until after the records were produced.
That's fine, but that's where the injuries are. So now we've got to figure out whether it's reasonably ascertainable to get there. The second your client was a shareholder, which was what, 1989?
1989, Your Honor.
He always had the statutory right to ask for, and if necessary, sue for company records, right?
With limitation, Your Honor, the statute that allows for the corporate records says that there has to be a pretty good cause in order to get to the records. You request them, you make a demand for them, as my client did in 2011 and in 2016. But then the court, you have to come forward with sufficient information to prove that you're entitled to the records. The Arctic case that's cited in here says that they don't, that records order for a records request is not a fishing expedition. They don't allow that. You have to come forward with enough information to prove.
Let's concede maybe that there's a hurdle there. Is there anything to indicate that if your client had received the records, that the misconduct would have been disclosed right there? You would have got the records, you'd have seen all these assets moving over to NTTS, right?
No, Your Honor, I believe that's the error of the lower courts. That's pure speculation. I believe that's reached far too far because Mr. Goebel was hiding assets at that point in time. The purpose of forming NTTS Inc. was to avoid a $2.5 million judgment that was entered in June.
I'm trying to get at, are you saying that the business records of Miracorp, your client's corporation, would not have disclosed any of this misconduct if you'd have, you have an accountant go look at it and the accountant's going to look at it and not find anything because they're all dummied up?
Your Honor, it's pure speculation as to what Mr. Goebel would have produced. And our contention is that by his own
records exist. That's not speculation. Can't we go back to 2011 and look at the books, whatever they were?
Well, Your Honor, the speculation comes into what would Mr. Goebel have produced? Would he have produced the records that showed all of his wrongdoings? We don't think so, based upon his history of wrongful conduct.
If he had, would the records have shown the misconduct?
If he had, we're speculating, Your Honor. We don't know what he would have produced.
Do you know what's in those records?
We finally got some records in late 2017 and 2018.
Or 2011 and 2012?
Yes. Yes, Your Honor. We did get those after we filed in 2016. There was a request for the friend order for the records. And Mr. Goebel fought vehemently for a year to not produce those records. So he continued to conceal those records. And finally, some were turned over. And in those records, there's nothing in the record, using the word record here twice, but in the records that were produced, there was only information with regards to Miracorp. There was not any information with regard to NTTS Inc., which was the company he transferred everything to.
Okay, fine. But would the records of Miracorp have shown the misconduct, shown the moving of the assets and the bonuses and all the distributions that you're talking about?
Possibly, if they would have been produced in 2011.
Well, but I'm confused now because I thought you told me you got the 2011 and 2012 records in 2017.
We got some of them, Your Honor, yes.
Okay, the records that you got, did they show
Wrongful conduct?
any wrongful conduct?
No. Not on their face. You would have had to, like you said, you would have had to gotten an accountant to, which we did. We finally got the information and we started reviewing and investigating and found out further what had happened. So the reason we bring up this concealment is we believe that the statute of limitations was told by Mr. Goebel's concealment of all these facts and his hiding of all this. We believe that Kansas law is very clear on that when there's fraud or intentional conduct that conceals matters, especially when there's a fiduciary duty. I don't want to lose track of the fact that this court in Wolf, it's an old case, but it's still good law. And in Wolf, this court said that when there's an injury, when the injury has been triggered, triggers a duty to investigate, a reasonable investigation. This court said in Wolf that duty is lesser or is reduced. What did this court mean by that? Compared to, so on the one hand, we've got the fiduciary duties, strict fiduciary duties, this court has said, of the major stockholder and the director of the company, Mr. Goebel. He had strict fiduciary duties to tell the minority stockholders what was going on with the company. He was entrusted to take care of the company on behalf of the Murrays, and he did just the opposite. And so he had this strict fiduciary duty to not conceal, to tell them all the material facts. So you have this one duty that's competing with, in this case, it's competing with the duty to do a reasonable investigation by, I'm going to call them, my clients, the innocent stockholders, minority stockholders. And presently what we have is the duty to reasonably investigate, as the lower courts have applied it, at least, has superseded and is being ignored, or rather the strict fiduciary duties are being totally ignored.
Who has the burden of proof? The statute, allows you to ask for the records, which you didn't ask for in 2011, 2012.
No, Your Honor, we did. We did ask for them, but we did not file a petition asking for an order. But on August 22nd of 2011, we did ask for the records. And
okay, so you got the demand letter.
That's not in the record, though, the August 22nd letter. It's the June letter that's in the record, correct?
no, the August 22nd letter is in the record, Your Honor.
Well,
but here's my
But
question.
the court said they weren't going to consider it, correct?
I don't,
District court said, I'm not going to consider this that's brought in later.
I don't recall that, Your Honor. But I can reference you to the record. It's volume 10, page 282.
Okay, so you demanded the records, didn't get them. Who has the burden to show what would have been in those records in order to toll the statute of limitations? So we're trying to figure out whether this is reasonably ascertainable. So, you had a statutory right to ask for the business records of the corporation. You do.
Actually, that's not quite correct, right? I mean, you only have the right to ask for to see the corporate books, the finances, if you can satisfy a burden of proof of corporate mismanagement, correct?
Yes, and Your Honor, it has to be very specific too. The Arctic case made it very clear that it's not a fishing expedition. So we go back to the Armstrong case, which talks about when a duty to investigate is triggered, right? In Armstrong, we had the mining case where trespass, and Armstrong had heard the explosions, felt the rumble, thought that they were trespassing years before the case was filed, but it got remanded back. And
Did your client in June of 2011 or August of 2011 have anything except a curiosity about the value of his 5% stock and the knowledge that Garmin was using Miracorp's label for something?
absolutely not, Your Honor. And that's taking, we're the movement, obviously, in this motion for summary judgment. And it's in the record. My clients did not know anything about that.
Is
If you
there
look,
anything in the record that indicates whether your client knew whether Miracorp was being paid for that right to from Garmin, or if they were paying Garmin for the advertisement? In other words, did they have any knowledge about whether Miracorp had paid Garmin or if Garmin had paid Miracorp?
the record, there are things in the statute, the statements of facts and so forth in the record that show that there was actually a relationship, a licensing agreement between Miracorp and Garmin. Garmin was paying Miracorp the right to use their search engine, if you will, in the Garmin product. What's in the record, Your Honor, is if you look at, again, this goes back to the triggering, right? What was the triggering event? And what is it that needed to be reasonably investigated? If you look at the August 22nd, 2011 letter, what's in this letter is very specifically, it says that it's for the purposes of determining whether the companies have been mismanaged. That's pretty standard language in these things. And whether other stockholders have received distributions or other benefits from the company that Mr. Murray had not received. That was the limited scope. That was the only thing they knew, that the only thing they suspected was maybe they weren't getting their share of the profits. That was it. There's nothing else in there that talks about triggering all of these other. This letter is August 22nd. In June is when the new company was started and everything transferred over. So this is 2 or 3 months later. There's no indication that my clients in this letter, had they known about the NTTS Inc. Transfer of all the assets and so forth, it would have been in this letter, but it's not.
Is there anything inappropriate about a licensing agreement?
No, there's not.
Is,
It's a good thing. We thought, my client thought it was a good thing. That's why they were curious about the value of their stock.
now, thereafter, they got some K1s, right?
That's correct.
Is there anything alarming about the K1s?
Your Honor, those K1s, first of all, they're a tax form. So good luck. Most people don't even know what they're looking at when they get some kind of a tax return from a corporation.
I couldn't tell anything from looking at them, but
But so
I'm asking you.
yeah, so a K1, it shows the losses and profits of the corporation, and here's your share. You got to pay taxes or you get a tax credit. What the court probably knows just from common knowledge is you don't get tax returns, you don't file your tax returns until the subsequent years. So in 2011, the 2011 K1 wasn't received until probably sometime in 2012, after the books were closed. The 2012 and 2013 and so forth. And those documents, I think it's a stretch again too far to impugn upon the Murrays, as the lower courts have done, to say there's evidence in these K1s that the assets were transferred just because some assets were disposed of. There might be a lot of explanations why the assets were disposed of. They might be 20, 30 year, 25-year-old assets that just were no longer any good, old computers that they needed to write off. Who knows if they were exchanged for money in kind. So the point is
Is there anything in the K1s to indicate that everything in the corporation was transferred to NTTS?
not at all. It just says some assets were disposed of.
Showed no business income, right? So all of a sudden, we've got a viable company running since 1989, and in 2012, we've got no business income. That's not a flag?
I don't believe it could be a flag if you knew what you were looking at. I would ask the court to recall what happened in the Phelan case, where the Phelans had actually received this deed and signed it, but it didn't reserve their mineral rights. And this court said that's one piece of evidence that would go to a trier of fact to determine whether or not they could reasonably ascertain their injuries. Just like the deed that the Phelans had in their possession. Yes, my client had the K-1s in the possession, but did they read it? Did they even understand it? And what does it even mean? All of this information and all the evidence needs to go before the jury, so the jury can determine as a matter of fact whether the investigation was, whether it was a triggering event for all of the conversion and all the, the 6 tort counts that we have. Was there even a triggering event? And then number two, was it reasonable to expect them to do a corporate records, file a petition? Would it have even resulted in anything, or would Lane Goebel have continued to conceal, and the statute of limitations would have been told?
Well, how would
What-
you
what
have met your burden of proof if you had actually filed a petition to look at the corporate books if they objected to it?
That's the point I'm making from Arctic. My client didn't know anything. It would have needed the very records that it would have had to been requesting that were in control and possession of Lane Goebel, and he was hiding them, or he was concealing them. They needed that information in order for them to have met their burden of proof, to have even have gotten an order in 2011 from the court to look at the records.
So what broke this case open? What gave you under 6211 a good faith factual basis to assert these claims on behalf of the minority shareholders? Apparently, you say with the assistance of a CPA. What were those records, and when did you actually obtain them?
Your Honor, in 2016, then something else happened. My clients did become aware of the sexual harassment lawsuits that had resulted in the 2011 judgment. In 2016 is when they learned of that. So another law firm, not ours, but another law firm sent the second demand letter in October of 2016, and it's in the record also. And now it talks about and inquires about the sexual harassment lawsuit and the judgment and the satisfaction of that judgment. So it gives us a sufficient basis, at least at that point in time, to ask the court. That was pretty good evidence that something was a foul. And so at least possibly with regards to the sexual harassment and the judgment and satisfaction, how it got paid for, how the judgment got, that all went before the court. And after a year fighting over that, the district judge finally, what happened was they failed to show up at a hearing, and the judge granted and gave him an order to produce the documents. So at that point in time, we got the document, then we got involved in the case, and we got the documents and started studying this and did research and did investigations, and then we just started uncovering one thing after another, just after another after another. And that's why we got 4 amended petitions, is because as we continued to investigate further, we found more stuff.
When was your first petition filed?
But were those, sorry, but can I just nail down
Yeah.
Sure.
what were those records? Were they like profit and loss statements? Were they a whole slurry of, I mean, I'm just trying to understand the nature of the actual records that you acquired through this,
Mostly-
action to enforce your rights as a shareholder.
It included some bank statements
Okay.
and canceled checks. It certainly was not complete in any regard or any manner. It included some financial statements, but not every year and not always complete. And anyhow, those things are not in the record. I'm just trying to answer your Honor's question. Yeah, it gave a sketchy picture. And then when we got involved, we started doing some more investigation and discovered this NTTS Inc. And it's just so the courts know too, in case you missed that in the briefs. 1989, Miracorp Inc. started, but it always did business as NTTS Inc. Or NTTS, which stands for National Truck and Trailer Services. So even forming the NTTS Inc. in June of 2011 was again a concealment to the public. And Goebel was able to transfer all of his business, and continue to do his business with his clients and his customers without their knowledge. They had no idea that there had been a change corporately.
Okay, so just to sum up, the court made its order on October 24th, 2017 to allow the inspection of the corporate records. And then I don't know how long it took for them to do that, but within 2 years after receiving that information, you filed suit, right?
That's correct, Your Honor.
Okay.
We received some documents at the end of off of memory. We definitely filed the lawsuit within 2 years. We got two sets of documents. One was at the very end of 17, I guess it would have been. And then some more came in March of 2018. Of course, then we had to analyze them. So yes, within 2 years, we filed the lawsuit.
I have one quick procedural question, or at least I think it's quick. Aside from ultimate conclusions, like the ultimate conclusion of whether or not something was reasonably ascertainable, ultimate conclusions about duties, is there any actual disputed material fact here in the summary judgment record? As I read it, I don't see one. That's why I'm asking.
Well, I don't think the trial court took into account at all the affidavit of and the statements that were made by Tracey Murray, where she said that they had no idea of all these actions until they got the records. So that was totally avoided. And
Well, but is there an actual factual dispute? In other words, where the parties are saying, you know, this pencil's yellow, no, it's red, you know, an actual factual dispute. I understand the dispute over the ultimate conclusions, but I just don't see a factual dispute, a concrete factual dispute. And I'm wondering if you see one.
Your Honor, I don't think there's a factual dispute as to now looking back with the privilege and the benefit of where we're at today with what we know. It's easy for us to go back and look and I don't think there's any dispute about the facts of what happened.
Okay, that was my question. Thanks.
Well, let me drill down a little bit on that. Now, in the statements of uncontroverted facts back and forth, Miracorp disputes that, or you dispute that Lane Goebel purchased the jet and then Miracorp leased it back from him. That was disputed, correct?
That is disputed, correct. And we believe that he bought that with company funds and he says he bought it.
Says he
personal
bought it
funds.
himself, right?
Right.
And Miracorp disputes that your client was even a stockholder, right?
Yes, even though they continue, even as of last year, to send them a K-1 so they can have to pay taxes on something they're not collecting, yes.
Well, because the statements of uncontroverted fact talk about consideration and that your client, there was no consideration.
Correct. So there's a dispute about ownership, correct.
And then Miracorp, you allege Miracorp bought the jet. And then there's the extent of whether or not your client asked for information from Mr. Goebel or his company, which is denied by Mr. Goebel, correct?
Correct.
So is it material whether or not your client was a stockholder?
Oh, absolutely.
They wouldn't have had the right to ask for records under any circumstance if they weren't a stockholder, right?
That's correct.
And so if the corporation or Mr. Goebel was hiding something from a non-stockholder, it would be irrelevant, wouldn't it?
It'd be a bad thing, but it'd be irrelevant to my clients.
Is there a dispute about whether Miracorp intentionally concealed wrongdoing or misconduct?
Sure there is. We allege that. We allege it because we believe a trier of fact with all the evidence under consideration will find the same way. we'll find that, all of the actions that happened in 2011 were intentional. And that NTTS wasn't by accident. It was set up 10 days after he got the judgment, the garnishment. Went,
No, I'm just saying, if for purposes of summary judgment, you know, whether there are no disputes of material fact, I mean, the parties dispute whether or not there was intentional concealment of wrongdoing or misconduct.
absolutely.
Correct.
That's a disputed fact as well. Yes,
Is there also a dispute about whether there was misappropriation of trade secrets?
absolutely. Yeah, everything that we have claimed and alleged in our petition is disputed. They've said, you know, not liable, didn't do it. So all of those.
Well, but I mean, not to go to liability, but for intentional concealment of wrongdoing and misconduct, that necessarily goes to the statute of limitations issue, correct?
That's
About
correct.
when something is reasonably ascertainable.
It goes to the reasonably ascertainable. It also goes to the tolling that we're allowed to toll for when there's a fraudulent activity or intentional misconduct.
How long are you claiming that your client should be able to toll the statute of limitations?
Until they got the records. That was the first time that,
Till the court issued the order?
no, not until the court issued the order, because it took a few months to get the records. So even when the order came down, it still took until March of 2018, I believe it was, for those records to be produced. And then they had to be gone through and by us. And so 2018, we filed in 2019 within 2 years.
So your allegation is that you did not receive relevant records to show corporate mismanagement until March of 2018.
That's correct, Your Honor.
So your allegation is that the statute of limitations is told from 2009, 2011 until 2018?
That's correct, Your Honor. We believe it's told because we believe all the actions were fraudulent and intentionally hidden and concealed. So that qualifies, we believe, for the tolling, but we also believe that there was no trigger, that our clients weren't aware of their injuries. There was no trigger for a reasonable investigation. So no trigger, no reasonable investigation was even required. And so from that perspective, they weren't reasonably ascertainable. You can't reasonably ascertain, you can't reasonably figure something out if you don't even know it exists. So for two reasons, we believe that the statute of limitations was told on the one hand, but on the other hand, the injuries weren't reasonably ascertainable until those records were received in 2018.
Thank you.
May it please the court. Ryan Paulus for the appellees. I want to, before I jump into my argument, I just want to address a couple of the questions that the court had for the appellants. First off, when it comes to, there's a question about were there any records that were provided that would allow the appellants to know that all the assets for the corporation, for Miracorp, were gotten rid of, were sold. And yes, so they did. And in his affidavit, the appellant states that he received a K-1 from 1989 through, I guess, up to the present, but at least 2012. And if you do actually look at that K-1 from 2011, which was mailed March 13, 2012, it lists every single asset that Miracorp owned: a folding machine, Hallmark trailer, snowplow, Ford truck, office furniture, computer equipment.
That's not unusual though, is it, to sell some of those things and acquire other new things?
Well, it's unusual when it's everything, every asset that they
Does
have.
the K-1 say it's everything?
Well, there's no line that says that's everything, but 13 different things. But to your point, does the K1 say it's everything? No, but what the K1 does say is that up through 2011, they had ordinary business income. They would pay Mr. Murray based on the profits that the corporation made. 2012 going forward, there was no more income. And he continued funds, and he saw that. He saw that the company didn't function anymore. The only income Miracorp had coming in from that point going forward was royalties, and royalties that was paid by NTTS Inc. to Miracorp for using one, other assets that they rented or were disposed of, and then two, for their proprietary trade secret identification of different mechanic shops that service trailers throughout the United States.
So in 2010, he had about $35,000. In
Sounds accurate.
2011, or was that 2011, he had a $15,000 loss. In 2012, he had some royalties. I'm supposed to know that there's corporate mismanagement from that.
What I think that any person would take away from it is that the company ceased to operate as a business. Simply just royalties.
And the timing of those K1s seem to also align with the requests for inspection of the records demand by the minority shareholders. And they get no response, right?
That's an excellent point. Yeah, so there's two demand letters that came out around 2011 timeframe. Within those demand letters, they laid. Within those demand letters, they said that Rob Murray has been in to see me. He's told me he's a 5% shareholder in Miracorp. No meetings have ever been held. No distributions have been made, and for many other things. And now he sees Garmin using the name and logo. We suggest that you call me. If no one calls me by the close of business Friday, July 29th, I will assume the worst and act accordingly. So you're right, there wasn't a response by Miracorp, nothing in the record anyway. So even based off their lawyer's own letter, and I know this was 2 lawyers ago, but even based off their own letter, the no response was a response, and then he assumed the worst and could act accordingly.
Was there in the summary judgment record evidence that there was a request to inspect records in summer of 2011, roughly?
I believe that the second letter that came after this one, they did ask for an inspection. I know they did in 2016, and then again in October of 2016, and then January of 2017. 2 more demands, also asking to inspect the records, but also laying out every single element in the claims that were brought in this lawsuit. So they
Well,
had,
but so, I mean, you can ignore somebody, and is there any indication from this letter or anything else that the Murrays had evidence they could bring to satisfy a preponderance of evidence, which would be required to force you to turn over the records at any time before 2016, when she said she saw the sexual harassment claim? Did they have anything?
well, Your Honor, they had the K1s that showed all the assets were disposed of. So I think that enough would be allow them to do an inspection, but they don't have to do an inspection.
And those were sent after the letter, right? In June of 2011. After that, they got the K1s, right?
Well, they got K1s for every single year since 1989, but the ones in question, yes, were disposing of the assets were received.
So your position is that they also had K1s, and from that, they should have known that something nefarious was going on in the way of corporate mismanagement.
Well, I don't think anything nefarious is going on in the way of corporate mismanagement,
So they didn't have any evidence of corporate mismanagement, correct?
but they had evidence that the corporation ceased to exist or at least function as a corporation in early.
let me follow my white rabbit a little bit
Yes, Your Honor.
whole. What's your view of shareholder rights under 1765? Shareholder production statute? You know, the shareholder makes a demand for the books and records of the corporation and stock stuff. What can any shareholder do under that statutory? Like, because plaintiffs had that statutory right to ask for the corporate records under 1765-10, right?
Yes, Your Honor.
So just walk through the process. As I'm reading the statute, I don't see a burden of anything other than they have to prove that they're a shareholder, which might have been in dispute, but won that fight, then we don't have this lawsuit.
Yes, Your Honor.
But so they have to show that they've got that. They have to show a proper purpose, but that's not defined here. But then it says if the corporation refuses, they have to prove that the shareholder is asking for a improper purpose is all I'm seeing here. So what's your view of how this statute operates? What rights did the plaintiffs have as shareholders to be able to look at the books and records of this company at any time?
Assuming that he was a valid shareholder, then yes, at any time, those records should have been turned over there. I think it's actually a minimal standard to meet, simply that you are a shareholder, so you have access to the records of the company.
And you contested that, didn't you? In the summary judgment motion and responses in the uncontroverted facts, you issued that you denied that there was any consideration paid for Murray's stock, correct?
I'm really glad you brought that up, Your Honor. So we do not contest the facts that underlie it. I don't think there are any facts in dispute in this case. We contest the conclusion drawn from those facts. Ultimate conclusion. So are there defenses to him being a shareholder? Absolutely. He didn't provide information. He fraud, but those are defenses. Not an argument to the facts of what occurred.
But that's certainly a reason to refuse to let somebody look at the books, right? If you contest whether they're a shareholder, because only shareholders have the right to look at a book,
Certainly,
at the
Your Honor.
books.
Do we have in the record business records of the corporation from the 2011-2012 timeframe?
So the records that were produced from the court in the action to affect the records,
I just need what's in this record here, and I don't remember.
or they're not. So what is in the record are the tax filings. And that's another good point. So you ask appellants whether or not the documents that they believe led them to bring the lawsuit were received. The lawsuit was filed within 2 years of that. They weren't. So the records were actually received in October of 2017. And this case was brought, well, it's either October or December of 2017. To make sure I'm accurate. And this lawsuit was brought February 7th, 2019. So
Is that date in the record? Because I'm reading from the Court of Appeals decision. It said that the district court ordered them produced on October 24th, 2017. So what is the date in the record that you produced them?
oh, okay. So thank you. So the order for the court ordered them, and then is it that in the record in this case? No, it's not. What we had to do is we had to look at the record from the previous case. File their certificate of service for providing the records, and that would.
But that's not in this record? What?
I'm sorry, can you clarify the question?
You're saying that they didn't file the lawsuit within 2 years of receiving the information?
Yes.
After the district court, you said that that you sent the the records in December of 2017. And I'm just wondering what the record site is for that date.
Okay, I mean, there won't be, it wasn't me, of course, it was a different one at that time too, but all courts can take judicial notice of filings within. I mean, so was it attached to summary judgment? No.
I'm confused about
Yeah,
this
Jim.
because if they filed suit in February of 2019, they're within 2 years of a December 2017 production of corporate
Right.
records.
That would be December 19. And if they filed in-
You'd get till December of 2019 to,
Right.
Oh,
if that's your launch date.
yeah, I apologize then, I must have messed up my dates from when it got filed. Yeah, I must mess that up, I apologize, but
But
either here-
regardless, are the records that were produced in late 2017, not worrying about a date, are those in the record?
no, they're not, Your Honor.
And so when you say the tax records, are we just talking the K-1s?
Yes, Your Honor, the K-1 filings, I think. it was-
Nothing beyond that?
No. And I guess the other thing that I want to address with the court in my last couple of minutes here is whether or not we're kind of putting the horse ahead of the cart. So we're trying to analyze whether or not but their argument is based on or premised on the belief that there were factual disputes regarding when the injury occurred, in what they knew or when they should have known it. But if we look at the demand letters from 2016, 2017, even back to 2011, they lay out all the claims that were brought in this lawsuit with those demand letters. So obviously they already had knowledge of it. So we don't have to guess when they could have figured things out because we know at least.
Aren't you presuming that? Aren't you presuming they had knowledge of some type of inappropriate behavior?
I'm just basing it off the words that their lawyer put in their demand letter that mirror the claims that we have in this case, outlining the allegations of harm that they brought.
Does 6211 come into play here at all, though? I mean, it's one thing to make an allegation that you maybe suspect the very issues that later become the factual basis of a lawsuit, but to have a good faith basis, in fact, to assert those claims in a pleading that is signed, which under 211, you have to then represent that you have a factual basis for those claims. Do you see the distinction or potential distinction between those two?
I do, Your Honor. I see where you're coming from there, but everything that they based, like the sexual harassment lawsuit, well, who paid for those settlements? Where none of that stuff is contained in the records anywhere, or it's not part of the file in front of this court. They knew what happened. They know those payments came out, but the records didn't change. There was no smoking gun in there where they said, "Oh, look, Miracorp," which wasn't even existent, didn't pay for anything, but NTTS paid for it as opposed to Lane Goebel or Shane Goebel. I see I'm out of time. If there are any other questions. Thank you.
Your Honors, I would draw your attention to some of the questions. This is the case that, Your Honor, you asked about reading of the statute with regards to the request for the records. This court in Arctic versus OTR spoke about and expounded upon the requirements, and that in that case, this court said, we don't allow fishing expeditions. You have to come forward. The first thing you do per that statute, Your Honor, is you have to make a demand, and you have to specify why you have a right. I mean, it includes, you have to show that underneath an affidavit that you're a stock owner. But you also have to come forward with something that's firm. And then in order to get the order, you actually have to you have to meet your burden of proof, that you have, a right to the information that you're asking for. And Arctic does a really good job of pointing that out. And so I would draw your attention to the Arctic
How do you
case.
get around the Lathrop and Gage letter on behalf of your clients and the August 2011 letter where they talk about want to examine the books and records of the corporation for the purpose of determining whether the company has been mismanaged and whether other stockholders have received distributions or benefits from the company that he has not received? That seems to be some awareness of something wrong.
I would agree, Your Honor. The August 22nd letter pinpoints what they think something might be wrong and is speculation on their behalf. They wonder, are other stockholders getting something we're not getting? And that's the only thing that they're really, that may be the only thing that I'll say was a trigger. All the other actions though, that we've asked for, conversion and unjust enrichment, all those things, there's absolutely nothing in the record. The August 2011 letter does not speak whatsoever at all to the conversion of all the assets or the unjust enrichment or the fraud or the.
We're talking about distributions that other guys got that I didn't.
Yeah,
That seems like,
that might be part of the fraud claim, but it's very specific. It doesn't talk of, there's no mention of NTTS Inc.
I understand.
Your Honor,
that.
if they would,
But the issue for us is whether reasonably ascertainable that something is amiss. Corporation. And so at least by August of 2011, we know that your clients, through their lawyer, have suspicions at least of the company being mismanaged. That's pretty broad. I think that would cover most any kind of corporate malfeasance. And then whether other stockholders have received distributions or other benefits that he hasn't received. That's a fairly broad bit of information that they've got. Now, in analyzing whether it's reasonably ascertainable, there may be other dots to connect, but it seems to me that somebody says there's a smelly fish here in the bucket and we need to figure out why it smells.
but mere suspicion's not enough because as Arctic points out, you have to come forward. You can't do a fishing expedition. You have to come forward and prove that you're entitled for the order. And
But that's a different fight
it's
than knowing that there's a problem. So
But
now I'm just saying, we know there's a problem. We know we ought to use these statutory rights to try to pursue it. And we've got this demand letter, but we're not doing anything, and then they ignore it. I mean, that'd make me run to the courthouse.
But if you run to the courthouse, Your Honor, you're not going to get an order. Because you have no evidence. All the evidence is in the records that Mr. Goebel's holding. So we have nothing. We have no way of getting the order from the court. Yes, we made a demand based upon some suspicions that we weren't getting distributions possibly, but that was mere speculation. In order to get the order, it would have been futile for us to go to the court. We had no evidence. In 2011, we knew nothing. We had no evidence to take to the court and say we were entitled to an order to inspect the records.
But now we're still gonna, after this letter, we're still gonna sit on our hands for 8 years before we file a lawsuit. And so figuring that out is the task, I think.
And Your Honor, I would say, look at Armstrong and Phelan. They go hand in hand. There has to be a trigger. In order for that duty to investigate to start, there first has to be a trigger. There has to be a shaking of the earth. There has to be something that puts you on notice that you better do a reasonable investigation. And there's no trigger. We didn't know anything. There was
So are
absolutely.
you
no trigger.
claiming that the August letter is just a bluff?
It's not a bluff. It's a suspicion. We want to know. I didn't write the letter, but on its face, it looks like we're saying, hey, in August, we're saying, we want to know if we've already said we knew about the tie with Garmin. We just want to know if we're not getting what we're supposed to be getting.
So a hey, I wonder is different from I have facts to show
Correct.
something is going on.
That letter doesn't say we have any facts. Those facts are in the records that we needed to get, and we couldn't have gotten them because we didn't have the evidence to go to the court and get the order.
Questions?
Thank you.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.